covering the confirmation hearings of Sonia Sotomayor, which are the hearing today. I think has begun to make news after an opening day yesterday. Let's bring in Senator Charles Grassley of Iowa, a Republican who sits on the committee. Senator Grassley, what do you think significant happened so far today?
Well, I think she has done a good job of backing up yesterday what she said when she said their basic approach to judging is fidelity of the law. And I'm sure that that was made as a statement because she knows the major concerns among us Republicans is whether or not she's going to leave biased at the courtroom door when she's doing her job. And I think she's backing that up very well today. And you've got to think of some of the really extreme statements she's made, maybe not so much in her court cases, but in her speeches and in her writings, that there might be a suggestion of pandering yesterday when she talked about fidelity to the law. And so today and the next 2 days, I'm sure that she's going to do everything she can to reinforce that. And the extent to which she reinforces that, it's very much more difficult for us to charge her with bias and not being blindfolded as a judge is supposed to be and not being a judicial activist.
She said today in response to Senator Cole from Wisconsin that Roe v. Wade, the decision that guaranteed or gave a woman a right to an abortion back in '73 with some constraints, that is settled law. What does that say to you? Does that mean anything? Because I realize that Judge Roberts said that during his confirmation hearings, that phrase, in fact, settled law.
Well, it's settled law until one of two things. Either there's a constitutional amendment passed overturning it, or until a majority of the judges come to the conclusion that something else ought to be done. But I think that when it comes to abortion, the only thing that's going to change that is when there's scientific evidence that conception is the beginning of life, as opposed to judges deciding when life outside the womb is viable. And that's a decision that rests on things that we don't know about today. Although it seems as science goes on, you get closer to the point when life is viable as you see a heart beating when you have a sonogram after just a few weeks.
Do you believe if abortion is covered in the new national health law bill that the president's trying to win by the end of this year, if abortion is included as one of the services, that will kill the bill?
On that point, what we're trying to do is to do what the present policy is within law, maintaining present policy. If we can maintain present policy, and why would anybody want to overturn present policy on that issue, then we ought to not have any problems.
So the Hyde Amendment, if it's upheld in the new legislation, if it's honored, that would be okay with you?
Well, don't you think after 34 years that's pretty settled law as well?
Well, that's up to you. Let me ask you about her statement this morning that it was a mistake. In fact, her phrase was, it was bad when she said that a wise Latina woman might offer a better opinion in a case than someone else. The fact that she said today that fell flat, she said that was bad that she said it that way. What do you make of that? Is that pandering, or what, did you use your term, or what would you call it?
Well, I hope it's not pandering. I hope that she's very sincere when she said it, and that it's not a deathbed confession just because she wants to be on the Supreme Court.
But you use a phrase like that, and it's so appetizing that people must think you mean that. Do you think it is a deathbed conversion?
Well, listen, I'm raising questions. Because she made these statements. I didn't make them. She wants to be on the Supreme Court. The president wants her to be on the Supreme Court. I've got a responsibility to be dispassionate and figure out whether or not she's playing games. I hope she's not. I don't have any reason to think she is, except we've got 3 or 4 days here to find out, because we're making a decision putting somebody on the court for a lifetime. And I've only made one mistake, one misjudgment of any of the 11 people I've been involved in, and that was Souter. And I don't want to make that mistake again.
What do you make of your colleague, Jeff Sessions, the ranking member on the committee from your party, raising the point that in her testimony when she was up for appellate court, she promised to recognize the need for real scrutiny whenever race is used in determining some kind of redress of past grievances or something, that had to be used in a very, very narrow way. And then he pointed out, your colleague, Mr. Sessions, that she never used that language when she decided the Ritchie case. She decided that in a cursory fashion, never brought up the need for a very tough standard when using any kind of effort of using race to redress past grievances.
Well, I presume that probably what it means is when she was here in the last decade to be on the circuit court and she responded to Senator Sessions that she either forgot what she had said or she had changed her mind in the meantime. But I think it's very important for justices of the Supreme Court to be reminded of what they tell senators in the past and what you tell senators during a confirmation decision, if they're coming from the heart as well as the study of the law, that you ought to stick by them when you're a justice just as much as you were when you were a nominee before the committee.
Is that your experience, that these justices stick to what they promise you when they come up for confirmation?
You know what, being a non-lawyer on this committee and not following every Supreme Court decision, I think I'm very inadequate to answer that question. But I can tell you that as a personal matter, there would be some times when I would expect that it would be perfectly appropriate for them to do it, as long as things have changed or not applicable to what they were when they were a nominee, because I find that all the time as a senator. I may make a promise during an election, you try to keep that promise, but if there's a good reason for changing it, it seems to me you have a responsibility to change it and stand on your thing. The only advantage, I have a disadvantage in regard to that. I can be voted out of office and a Supreme Court justice can't be.
It's so great to have you on, Senator. Thank you so much for coming on with your candor and your toughness. It's great to have you. Thank you for taking a break and giving us your wisdom. Thank you, sir.
Thank you.
They're getting back to the hearings right now. They took a 10-minute break. That was Senator Charles Grassley of Iowa. I thought, Andrea, I thought that was great the way he talked there. He's so tough. He's so common sense the way he talks.
When he said he's only made a mistake once and 11 times.
I love that, the way he talked.
He says he is dispassionate. I still think that he could end up voting for her, but I think he's going to be a tough vote for her to get, especially because of abortion, which is a very big issue with Chuck Grassley.
I know it is. He said that again the other day.